Welcome. Today we're diving into the UK's Data, Use and Access Act 2025, a major update to the country's data protection landscape. This new law brings significant changes to how organizations handle personal data, aiming to clarify rules, reduce unnecessary bureaucracy, and strengthen protections for individuals. Over the next few minutes, we'll break down the most important updates, what they mean for businesses and consumers, and the practical steps companies should consider to stay compliant. Whether you're a privacy professional, a business leader, or just curious about your rights, this overview will help you understand the essentials of the new act. One of the headline changes is the introduction of a new right for individuals, the right to complain directly to the companies that control their data. This means if you believe your data rights have been violated, you can now approach the company first, before escalating to the regulator. The Act also updates how companies must respond to data subject access requests, clarifying that only reasonable and proportionate searches for personal data are required. These changes are designed to make the process more efficient for both consumers and organizations, reducing unnecessary burdens while ensuring individuals' rights are respected. The Act brings important changes to automated decision-making, or ADM. Now, companies have more flexibility to use ADM, especially when special category data isn't involved. For example, businesses can rely on legitimate interests as a legal basis for ADM, making it easier to use AI and automation tools. However, safeguards remain crucial. Companies must inform individuals about decisions made by ADM, allow them to contest those decisions, and provide a way for human intervention. This balance aims to encourage innovation while protecting individuals from unfair or opaque automated outcomes. Key legal update is the introduction of recognized legitimate interests as a new basis for processing personal data. This allows organizations to process data for specific purposes, like preventing crime or sharing data with public bodies, without needing to perform a balancing test each time. The Act lists these purposes in a new annex, providing clarity and reducing compliance uncertainty. Common activities such as direct marketing, internal administration, and network security are also covered. This change streamlines operations for businesses while maintaining important safeguards for individuals. Act refines the rules around purpose limitation and further processing of personal data. Now, if a company wants to use data for a new purpose, it may be allowed if the individual consents, if it's for scientific or historical research, or if it's in the public interest. The Act also clarifies when further processing is compatible with the original purpose, making it easier for organizations to innovate while staying within the law. However, stricter rules apply when data was originally collected based on consent, ensuring individuals remain in control. Scientific research, the Act introduces more flexibility. When personal data is collected for research, companies may be exempt from informing each individual if it's impossible or would require disproportionate effort. Instead, transparency information must be made publicly available. The Act also allows for broader consent, so individuals can agree to their data being used for an area of research, even if the exact purpose isn't known at the time. This supports innovation in science, while ensuring transparency and respect for data subjects. Transferring personal data outside the UK, the Act introduces a new data protection test to assess whether such transfers are allowed. Instead of requiring equivalent protections, companies must now ensure that the protection in the destination country is materially lower than in the UK. This approach is more flexible than the EU, making it easier for UK businesses to operate globally while still safeguarding individuals' rights. Companies should review their transfer risk assessments and update documentation to reflect this new standard. Children's data receives special attention under the new Act. Companies offering online services likely to be accessed by children must consider children's higher protection matters. This means thinking about how to protect and support young users, recognizing that children may not fully understand data risks, and adapting protections based on age and development. These requirements strengthen the existing age-appropriate design code and ensure that children's privacy is a top priority for online services. What should companies do next? The Act offers both new opportunities and responsibilities. Businesses should update their data subject rights policies, privacy notices, and internal documentation to reflect the new rules. Special attention should be given to AI and ADM policies, legal basis disclosures, and processes for handling children's data. By taking these steps, organizations can ensure compliance, reduce risk, and build trust with customers. Staying proactive will help companies adapt smoothly as the Act's provisions come into force throughout 2026.